In the realm of justice, the path of alternative dispute resolution is not merely an alternative. It is a transformative journey towards resolution where mediation and collaboration illuminate the corridors of understanding and replace the shadows of contention. Good evening, participants, and today on the fourth edition of short-term course on legal and early law with special reference to RTI, PIL, EDR, consumer rights, and rights of citizens. Today we will be covering the topic Introduction to ADR and its branches. And with us we have our esteemed speaker, Dr. A. Is my voice clear?
Not that much clear. So please go carry on,
Hello,
carry on,
am I
carry on. Yeah,
clear?
a
Yeah.
second slow.
Okay, sir. I hope I'm audible right now.
Again slow.
Hello.
It's low.
There might be
Voice
an.
is low.
Okay, sir.
Oh,
One
Ah,
second.
now it's fine.
yeah,
Yeah, please carry on, fast, fast.
that flow is fine.
Okay, so I'll start again. In the realm of justice, the path of alternative dispute resolution is not merely an alternative. It is a transformative journey towards resolution where mediation and collaboration illuminate the corridors of understanding and replacing the shadows of intention. Today, on this fourth edition of short-term course on legal aid and lead laws, with special reference to RTI, PIL, ADR, consumer rights, and rights to victim, we'll be covering the topic Introduction to ADR branches. And with us, we have our esteemed speaker, Dr. A. Marisport. Sir is an assistant professor of law at Gujarat National Law University, and his area of interest include alternative dispute resolution and criminology. Sir has published various research papers, chapters in various fields of law, especially on gender and disability studies. Further, Sir has participated and presented papers in numerous and diverse topics, well recognized seminars and conferences. In addition to this, Sir has chaired and co chaired several sessions on both at national and international level, and thus, Sir has been very active in every project undertaken by the college in furtherance of pro bono and legal lead. Sir is a source of inspiration for anyone who wants to pursue a career in social work, area, and criminology. So today we have our esteemed speaker with us and he'll be continuing the session. So over to you, sir.
Okay, thank you. Just I am sharing the screen. You have to make me as a presenter. Okay.
Yeah, it's done.
Yeah. I'm just scared. I hope my screen is visible now.
Yes.
Okay.
Yeah, we are able to see files.
Just
Sorry, folder, and there are
yeah.
files are there.
No, it is now file is opening. Just check it out.
Okay. Yeah,
Yes,
now
sir,
the
it is
link is there.
visible, sir. Negotiation is visible.
Yeah,
Okay,
yeah,
now please
that's right.
carry on.
Okay. Now, please remember. Uh, thank you. Please remember. Uh, I am going to give introduction to ADR, and I will be highly rather giving much attention on local earth because that has been asked by the organizers to do, right? Remaining conceptual aspects with regard to mediation or negotiation or other areas, respective faculties you can ask, or if you want to personally interact with me, yes, Kalpesh sir has my number. He will share it with you. You can call or you can write a mail. I will definitely help you. Right now, okay. First of all, we should understand. Okay. Yes, who has written that World Cup related question? Yes, Muthuswami, right? Who is that? Okay. Now let us get into this dispute. Now there are three terms we should understand: being a law person as well as persons who are facilitating um, dispute resolution. Dispute, conflict, and difference. There are differences. Please remember, if you go by ascending order, first comes difference, then comes dispute, then comes conflict. In a way, I'm just giving the example. Let us say Dr. Kalpesh is saying, sir, you have to take the session on 7 o'clock. Whereas I am saying, no, I cannot start. I will start at 6. Now, please remember, in this case, we have difference. Now, if it is supposed to lead to dispute, there is one step further. Then Kalpesh is saying, okay, if you are not starting 7 o'clock, I'm not going to give the chance. There you have the dispute. Now, how conflict comes? As far as conflict and disputes are concerned, there is a fundamental difference. Dispute comes when you have either written or oral contract. Because you have agreed terms, there must be some breach, or you may require some modification. Hello? Is it, am I not audible?
Yes, yes, you are audible. Participant, please check your mics. Yeah, you are audible. Please carry on.
Okay. Okay. Now, please remember this very essential: conflict. Conflict comes non-contractual disputes, be it family, or be it, now you may say that family is a contractual one, but still that's not a contract disputes per se, especially Indian context. Or you take, now take the case of Israel Palestine. It's a conflict because there was no contract between them, and they have a kind of issues, or kind of differences in a particular area that got aggravated, so they have the conflict. Now if you take India, Sindhu Sindh river dispute, we have arbitration, international arbitration under that. Okay, now it's a dispute because we have a treaty for sharing the river. Similarly, um, you have a kind of differences and disputes could arise sometimes together in conflict also, because certain cases conflict may or may not have disputes within. Let us take the case of South Africa, right? We have a conflict between black and white people. So in that case, there were some arrangements, agreement, again disagreements. So again, if you look at, but one thing we have to remember in general, conflicts in general doesn't require any kind of contractual arrangements between the parties. Now take the case of Kaveri between Karnataka and Tamil Nadu. It's a kind of interstate water dispute. Why it becomes interstate water dispute? Because there was an agreement, or there is an agreement, because still that agreement in place. Similarly, take Periyar, okay, Mulla Periyar Dam agreement. So there is that's where we have interstate water disputes. So please understand these three terms. Right. Now you may ask, so does the mechanisms which we are discussing, are these mechanisms only connected with dispute resolution? No, please remember, it always helpful to resolve conflict, differences, and disputes. Right? So please remember. Now let us get into the types of dispute resolution mechanism. First one, litigation. Second one, arbitration, mediation. Then negotiation. Then power. Then avoidance. Okay, how many of you are hearing some of the terms before, especially avoidance, negotiation, and you can say that mediation? Kalpesh, please let me know whether my voice is audible properly or not.
It's audible, audible.
Properly audible, right?
Yes, yes.
Okay, I think then there is a network issue from the participants. Okay, now please look at this case. Um, this power and avoidance, very interesting thing, right? Okay, so here, um, let me get into each angle. When we are going to, let us say, a kind of ascending order, if you ask somebody to give ascending order of dispute resolution, then I would say that first one comes avoidance, second one comes negotiation, third one comes mediation, fourth one comes arbitration, and fifth one comes power. But some people may put power also first one, right? So power is a kind of interesting thing. I will give the yes, good question. I will come to that. Here, this particular slide, I am not going to highlight anything written format. I am going to only discuss. Please give attention to this. Okay. Now, imagine a situation, two groups in the college having the class. Now, Kalpesh is working in the university, right? On behalf of Kalpesh, you are going to decide. Okay, assume that Kalpesh is in the student welfare officer or student welfare um, head department head, right? Now you are going to decide what can be done in that case. Now you are having the power. What you will do? Tell me. Two students group having the clash. Yes. Any answer? What you will do? Okay. I think there is no response. Let me get into another example. Now, okay, Aparna Rai mediation. Okay, Amit Kumar. Okay, fine. Now, let me alter one more scenario, rather given one more scenario. Kalpesh is the employer. I am the employee, right? Now, Kalpesh is giving too many tasks to me, right? I knew that Pooja is not at all doing any work. I'm having anger on Kalpesh, right? Now, which kind of dispute and what can be done in this case? Now, please remember you have to think about Kalpesh side as well as my side. Kalpesh is the employer and I am the employee. Yes, we can simply say that mediation and other things, but how the power dynamics works here? Okay, litigation. Yes, Samyukta, you told litigation. What, in which way? Yes, is it labor court? No, could you anybody go beyond that? Okay, Kalpesh is sitting in the position to influence. Okay, now conciliation also, please remember, that's where many of the issues, if you look at it, take the case of many of the employment issues. You might have seen Air India, or you might have seen Jet Airways, or you might have seen some of the renowned cases, even workman violence, right? Sorry, workplace violence also. Now this power plays a role. Please remember, through power disputes may be aggravated, resolved, or mitigated. I'm using two things: aggravated, mitigated, and resolved. Now, please remember. Now, since Kalpesh is the employer, I am the employee. Because many of the times what happening in this power imbalance situation, what we are doing, there is a dominance already there. Now, how many of us, because many people are employing, right? Even some advocates are working under seniors. You have the power imbalance. There were some occasions workload maybe increase or decrease. But can you able to resolve that dispute or resolve that particular issue? You might not, because that power plays a role, right? Now here Kalpesh, what we'll do? Okay, if you don't work, I will reduce the salary, or otherwise you may leave. Please remember, many of the private institutions, why workers are not even asking too many things, because of power. Again, I am not saying power is a suitable mechanism. I am telling power is one of the dispute resolution mechanism. Okay. Now, many of the international issues, conflicts, US comes. When US comes or Russia comes, certain uh, directions the dispute may go or conflict may go, because their power is something different. And please remember, in a particular dispute or conflict, sometimes you may have a combination. First one, you may have a negotiation. Second, you may have avoidance. Then, or you can say that you may have power, then avoidance. You can have combination also. You never know. Okay. So I hope you understand what is the meaning of power here. So many of the cases, power is used for resolving dispute. However, through power, if you are resolving the disputes, the dispute may be resolved or dispute may be silenced, but the disputants may not be happy. I'm telling you 99% the disputants may not be happy. Like litigation, okay, who is right, who is wrong, but ultimately time cost. Here, as compared to litigation, power is, barring few cases, a kind of double-edged sword, right? So that's where power is one of the option, but please remember, you should not use it. Let us take the issue of two kids are having clashes. Let us say Kalpe's son and two sons were having clashes or are having clashes. What Kalpesh will do? He simply order, "Arey, ye mat karna. Say sorry." Then they will listen and say sorry. Then and there their dispute resolved or conflict resolved. Are they happy? That's different thing, right? That's way that in that way power plays a role. So power is one of the method of resolving dispute. Then we go to other methods. So litigation means it's a filing of cases before the established tribunal and forum. Then we have alternate dispute resolution. Please remember, power is a kind of alternate dispute resolution. Please remember, if you look at it's a tricky thing as far as the satisfaction of the people is concerned. No, it may not be the viable option. You can say that it's a kind of additional boost up, but you cannot use it a kind of main dispute resolution mechanism option, right? Then as far as alternate dispute option is concerned, you have okay, that is arbitration, mediation, and negotiation. Now look at this example here. When a dispute arises, so company, employer, and distributor and customer. Even take the case of distributor and customer. Let us say if somebody purchased too many things on installment on a particular same shop, still distributor has the upper hand, right? So in that case, he has to come down. So there is power imbalance. and based on the information also power imbalance take place. Right. Now take the case of employer-employee and dispute. These cases, so sometimes what people force the power to meet the demands. So that way, one way you can resolve the dispute. However, it's not a viable option. Second, okay, then we can have right-based approach, then interest-based approach. I will explain what is right-based approach and what is interest-based approach. In right-based approach, we are going to decide who is right, who is wrong. Interest-based approach, instead of looking into who is right or wrong, we will try to find out a middle path, right? So that way we are resolving it. Okay. Now, please remember, I'm going to go back to previous slide. With regard to dispute resolution, there are three ways you can classify the dispute resolution. First one, right-based resolution and interest-based dispute resolution. Second one, that is third-party facilitated dispute resolution, and between the disputants, that is dispute resolution which can be resolved by the disputants. Then you have one more options, avoidance. That is, okay, in the avoidance you have avoidance only, but now the other two categories I'm telling you, with regard to third party facilitated dispute resolution, mediation, arbitration and litigations, these three are third party facilitated dispute resolution. But as far as the ADR is concerned, litigation will not come. Then third party facilitated alternate dispute resolution means mediation and negotiation, right? There are other methods, DAB, DRB and some other boards. You no need to confuse, because these boards either falling under the arbitration category or mediation category, right? So you no need to panic. Now then comes parties themselves. In that you have options, that is expert panel. The parties, they themselves create expert panel, or they themselves negotiate. Anyway, both way they are doing negotiation, right? These two way, they are rather these two types are very, very important. Now let us get into the right based and interest based. So here, what is right, what is interest? Please remember, whenever we are dealing with any ADR setup, okay, be it arbitration, be it mediation and all, many ADR setup, we should understand this term. Especially I'm telling you conceptual framework, like the differences between dispute, um, the conflict and difference. Similarly, you should know the importance of understanding the difference between right based approach and interest based approach. Okay, I will explain what these two things are, then we will move to Lokadalat. Right now, little bit I will touch upon negotiation, then only I can able to tell this right based and interest based. Okay, with regard to negotiation, in general, negotiation means it's an agreement. So both parties, when they have the dispute or conflict, they try to discuss themselves and come with a kind of settlement. So that is known as negotiation. You can say that samadhan in Hindi. But here in negotiation, you don't have the third party. Only the disputing party are the people who are having the conflicts, right? So there are various ways you can classify the negotiation. One is position or interest based. So position here connected with the term right. So position or interest based. Position or interest based, which is otherwise known right or interest based. Second, dispute or deal making negotiation. then cross-cultural negotiation. Okay, price or non-price negotiation. Okay, now let me get into negotiation. I don't know how many of you are having a kind of work in law firms or work in some of the corporate offices. So there you will have a deal making negotiation. So negotiation is the one you can use it for resolving dispute as well as your future deals. Okay. Okay. Now, like the first slide, this slide, please look at this slide. It's only 2 questions I asked, right? But this slide, again, I will be giving too many examples. Kalpesh, whether the participants able to unmute themselves or not?
Yes. Participant, yeah, they can speak.
Unmute, right?
Participant, please
Okay.
raise your hand. I will unmute you.
Okay. Now, I'm going to ask a question one by one. I will give a time and you have to respond. First question, right? Kalpesh is having 1 orange, right? Now Pooja and Marisport is demanding. Kalpesh, he himself hungry. He would like to drink. That is different thing. But he has to divide it to Pooja and Marisport. So conventionally we can divide. Half off. Is there any other way we can divide the orange so that Pooja and Maris will have the satisfaction of having the entire orange? Yes. You have 30 seconds. You have 30 seconds. You have to respond. Yes. Okay. Harsha is saying make us. Okay. Okay, Satyam. I'm repeating it. Kalpesh is having 1 orange, but he has to divide it to 2. And there are 2 people claiming Marispot and Pooja. However, you should not cut the orange. But the division in a such a way that both should have the satisfaction of having entire orange. Okay. Samukta asks. Okay, make juice. Okay, Kalpesh, somebody has unmute, asked, raise the hand. Just check it out. Whether she would like
Nobody.
to raise. Yes?
Participant, you can raise your hand. I will unmute you if anybody want to speak.
Smita Bhavani. Okay. Yeah,
Just peel it and divide into 2. Bring one more orange. Who comes first or more
no,
hungry
actually,
and
somebody
wait?
raised the hand. Smita Bhavani.
No, I am not able to see.
Okay. Okay. Who is that Kalpit whom some answer has given? Actually, different answers are getting. I'm getting. Even somebody say that who waited a longer time, you can give it the orange. However, why we
One can
distribute?
have the
Okay.
pill, other
Okay.
can eat
Let
the
Kalpesh
fruit.
eat the orange so that there is no clash. Okay. Good answers. Okay. Negotiate. Please remember, I'm giving the answer here with another question. Now, Kalpesh is having 2 eggs. Say Marisport and Pooja is fighting. Marisport and Pooja is fighting, right? So Kalpesh again, he thought of eating the egg, but what to do? He is in the position of dividing it. Please divide the egg in a such a way that both have the satisfaction of having entire egg. Yes, another 30 seconds. understand the question carefully. Dividing the egg for two people, but make sure that both party will have the satisfaction of having the entire egg. Yes, how it is. Yes, Harsha has raised the hand. Okay, make the omelette and give. Fine. Interesting. Interesting options are coming. Yes. Pooja, who is the host for this event? Only host can make this unmute. Okay. Otherwise, okay, I cannot. Okay, I cannot unmute it. Fine. Even I cannot use the shortcuts. Fine. Harsha has raised his hand. That's fine.
Sir, you are the host for the meeting now. You can
Yeah.
try it once
What?
again.
What? Pardon
You
me?
are the host for the meeting now. You can try it once again.
No, no, I cannot do it because I while sharing I cannot use the shortcuts. Better you make Kalpe sir or somebody else so that unmute it. So that he can allow it. Okay, fine. That's not an issue. Technicality, even somebody is responding in the chat box, that's fine. Please remember, this is rather these two examples give how we can go about it. Now let me get into the third question. Okay, let me take the pizza. There is one pizza, right? He purchased from Domino's. Again, two people are claiming Pooja and Marisport, right? So you have to divide. How it is possible? Again, the condition is the same. Both supposed to have the satisfaction of eating entire pizza. Yes, respond. Okay, Sachin has raised a hand. Okay. Okay. Okay, mediation or arbitration. Okay, you can do mediation or arbitration, but anyway, ultimately you have to take the decision, right? So please remember, let me come to the answers for three questions. Here you can choose any means of dispute resolution. But right-based dispute resolution says that who is right, who is wrong, or you can do split. That's a right-based. But Kalpe's giving because of these two are friends, right? Now these two are friends, he can give. But what happen if he divide? He may not, and I ensure that both have the same. But please remember, right-based dispute resolution or right-based resolution of the dispute always get into the merits or what they want, what the disputants want. Whereas if you get into interest based, why they want, right? This is very much required. What they want and why they want. Okay, what they want and why they want. Please remember, these two questions look like similar, but there are some difference. Now I am just looking at Kalpesh, right? He is having two
Smita has
friends.
raised as Smita. Smita,
Yes.
she has raised hand. Smita Puvani. Dr. Julian. Over to you. You want to speak? Dr. Julian and Smita.
Yes, would you like
Yes,
to
please.
speak?
Smita, Dr. Julian.
Okay, let me carry on,
No
Kalpesh,
problem.
if they want to
Yeah,
comment.
please carry on. Yeah, please carry on.
Okay. So what they want and why they want. Please remember, now look at the shoes of Kalpesh. He will ask, okay, what they want orange. So if he is not asking why they want orange, what we do, everybody divide the orange, cut the orange and give it each. Or otherwise what happened? Make the juice out of it and give it. Even that time also, it will be half. But if you ask the question, why they want, why they want, sir, why they want, if you ask, let us say Pooja is asking for juice. Pooja is asking for juice, whereas Maris is asking for peel for doing facial. Then he can do that way. What I can do? Entire juice may be given to Pooja and peel may be given to Marisport. Now here we are enhancing the pie or enhancing the utility of the orange. Then you may ask, sir, what if? Yes. Why we have to prove the needs? If they say why, for that he no need to do that. He asks the question why. That's in fact this question, interesting question. I will give one more example. Yes, that's where we are asking, right? Why? We are asking why. Then they may say that. Okay, I may say that I need facial. She may say that juice. So accordingly, Kalpesh will do. Right. After asking only, he will do. Then take the case of egg. Somebody like white part, somebody like yellow. So you can divide. Then there is a case of pizza. Somebody like crunchy part of the pizza. Somebody like toppings. Even sometimes what happen? Somebody like more toppings than this pizza. So what you can do? The more topics you can, that way also you can divide. So that you are enhancing the pie without adding anything. Right? So rather than splitting through the interest, you are enhancing. Now I will get into one step ahead. What is this interest based approach? I hope everybody aware of the Birbal story. One interesting story. Two mothers were claiming one child is theirs. That is A, mother A also saying that it is my child. Mother B also saying that this is my child. So A and B have the clash for child. Now that time so we don't have DNA. Now we don't have the DNA option that time. I'm talking about Akbar era, right? Even there was no evidence which clearly prove that somebody has stolen the child. Now how we ensure or how we resolve that case? Please remember, Birbal did resolve the dispute through interest-based dispute resolution only. Because in that case, right-based approach he might have taken. Yes, some people say that it is Solomon story, but okay. So here, this Solomon's story, somebody say that it is been Solomon story, but somebody says this Birbal story. If you look at our model medicine manual of India, it has been highlighted Birbal story. Okay. Anyway, now look at the ultimate reason for the highlighting this story. What he did, DNA there is no option, there is no evidence, but what he did, he had taken the interest based approach. Okay, what he did, he asked the soldier to keep the body in the palipede, right? Palipede, and he told that okay, let us cut the baby. But his intention was not cutting the baby. He knew, okay, real mother always have the intention of saving the baby. So keep that in mind. What he did, he asked the soldier to cut the baby. But what happened? The real mother told, let the child grow with her I withdraw my claim. Then Birbal or Salman, whosoever maybe, he had given the child to the actual owner, actual mother. Right? This is a kind of interest-based approach which we can take place. That only have possible in negotiation and mediation. Please remember, some of the Western books, which I always say that arbitration are also kind of adversarial method. They say that it's an alternate dispute method, but it also having a kind of adversarial thought, because it is having right-based dispute resolution approach. Who is right, who is wrong? It doesn't facilitate the interest-based approach. Now let me come to the interest-based approach. How it works. Now Kalpesh is having a kind of um, apartment, okay, at Baroda. So I have just joined an university job, right, in Baroda. Now he has given a kind of accommodation, but he asked me, please pay at least 2 months rent in advance. Then I told, I'm a fresher and other things, so many things. Then no. Kalpesh is saying, without giving advance, I'm not going to do. I'm not going to allow you to stay. Now, please remember, this is a right-based approach. Now, if we further negotiate or further get into other shoes, then Kalpesh is saying, no, if I'm renting it because I'm having immediate need for payment of my fee to my child's school, then I'm also saying, I haven't received my first salary. Once I receive my first salary, then only I have the income. I'm having first job. So if you get into that, then they may say that, okay, instead of 2 months advance, better you can have 1 month. Or you can say that, okay, you can give instead of 2 months, 3 months advance after your first month salary. Possible. Please remember, if you go by law, yes, 2 months advance is permissible. Kalpesh is right, absolutely right in asking advance. He has the right to give his home or not to Marisport for rent. But please remember how this interest-based approach plays. Similarly, hiking of rent. Sometimes what happen? Owner says that no, I haven't hiked the rent. At least the expenditures have been increased. Even cost of living have got increased. So what I should do? Then this tenant may say that, sir, I haven't given any hardship. Hardly I am staying. Then what to do? They may be coming. Okay, instead of hiking this much, at least hike this much. So they may have a kind of in between negotiation. So that's where the interest based negotiation helps, right? It's a kind of win-win situation for both. So mediation and negotiation, even some other area mechanisms like DAB and yearly neutral evaluations, helps for having interest based dispute resolution. Okay, I hope you are able to understand this one. Okay, so I'm not going to deal with much on negotiation now. I'm going to move Lok Adalat. If you have any questions, you can note down. I will take together at the end. Okay, now we are going to deal with the topic Lok Adalat. Okay, just a minute. There is an issue. Just a minute. I'm just coming. Okay. Okay. So section 19 and 19 to 22, and later after 2002 we have new section 22A. 22A to 22E we have various provisions connected with permanent lok adalat. Now lok adalat means people's court. People's court. So here bit background, in 19 I think 81 82 we had first lok adalat in Junagat, Gujarat, right? It's a kind of pilot project. Now, how this pilot project and all come, actually, there is an interesting story. In fact, this family courts amendments and all, everything come on based on pilot studies. How the study come and all to reducing the backlog of cases, various committees have been constituted, and even Supreme Court itself tried to manage various aspects. So that's how we have various development taken place, right? So similarly, one of the options uh, come to help was Lokalat. So in Lokalat, it's a kind of Panchayat, that is early day Panchayat model. But here, instead of the third person who is an ordinary person, here it may be sitting or retired judge. That person may be the presiding officer, right? So in Lokalat, what actually happened? There will be three members. One member who is having the judicial knowledge or who is from the judicial background, either um, district or high court judge. That kind of qualification he has to have. He may be retired or sitting. Then you have other two members who may be an advocate or who is having the knowledge about uh, social work, economics, or in general resolving the disputes or consumer affairs. So that way, right? So here these people sit together, and whenever dispute comes, they try to resolve the disputes through conciliation or mediation made. Conciliation or mediation. So please remember, they are resolving the dispute through conciliation or mediation. Now, what is conciliation, what is mediation, you will be studying, but in Indian context these two terms have some minor differences. As far as mediation is concerned, the mediating third party simply keep uh, kind of uh, away from the providing option. So the mediator just facilitating the parties, they themselves having the option, whereas in conciliation, the conciliators may, depending upon the situation, give options. So this is the difference between conciliation and mediation. So in Lok Adalat, sometimes, in fact, as far as my knowledge goes, most of the decisions may happens on the form of in the form of conciliation. So in conciliation, please remember, the conciliator give the options. Ultimately, the parties, they themselves agree. It's not the conciliator decide. Okay, so we should remember. So similarly, in the Lok Adalat, the presiding officer and other members, they will ask the parties and highlight their issues. So they will look at the disputes, and they will ask the parties to negotiate. If there is a roadblock in the negotiation, they may give their inputs. If it's up to the parties, they may agree or not to agree, right? So here, that way the dispute got resolved. Now please remember, the cases which can be referred for mediation, Lok Adalat, very interesting thing. If you look at 1921, any pending case are yet to be filed. So both cases can be filed. However, the cases must be civil nature, civil and commercial, or even matrimonial cases. You can refer it. Again, there is a caveat. Criminal cases, you cannot refer it. For example, 498A case, you cannot refer it to Lok Adalat, but you can refer for mediation. That's different thing, right? So civil and commercial and family cases you can refer, and if again it's depend upon the parties. If they're coming the local then they can, but in local cannot insist or rather compel the parties to come with a settlement. At the in the local if the parties not at all agreeing anything, then it can refer the case back to court. Or if there is no court case filed, then the local may give the option to the parties. It's up to them to decide what can be done, right? Okay, let me get into this. Let us look at the benefits of local adat. So with regard to local adat, there is no court fee for the local adat proceedings. Even there is no requirement of advocate filing. Even you yourself approach to the legal services authority, then they will refer the matter. Okay, so the proceeding cost is very less. So if there is a pending case is being referred to local adat, then there is no such kind of high-fi fee. Even already you have paid fee for your case hearing before the court. Either it could be fully or partially refunded, depending upon the state legislation. And please remember, though the judge only the presiding officer here, but he is not going to follow issuance of summons, hearing arguments. Those things are not at all there. It's a mere summary proceedings. Even 1 or 2 hearings, you can have a settlement. That's possible in lokalat. And please remember, once the lokalat is been conducted and the parties have have resolved the disputes through lokalat, then what the lokalat will do, it will convert the settlement into lokalat award. So whatever the terms of settlement parties agreed, it will put into writing, and it affixes that is the lokalat members will affix their signature. As a result, it will become the award. And please remember, you cannot challenge the lokalat award. There is no appeal mechanism. So once the lokalat award is passed, it will become final and binding. Now this is a kind of data. Okay, there is a question, interesting question. I will answer the question here itself. Very interesting. Please remember, as per section 89 of the CPC, if the civil court decides there is an element of settlement in a dispute, it can refer the dispute to any form of ADR, be it arbitration, mediation, local or judicial settlement. So it can decide, it can refer. There is no problem. Other than that, if the parties they themselves, either one of the party is willing, still it can be referred to lokalat. That's possible. But as far as commercial courts act are concerned, it directly give the mandatory mediation. That is pre-dispute initiation mediation, right? That option is there. So lokalat option is not there as far as commercial courts acts are concerned, right? Now this is a data I have taken it from NALSA. Anyway, it's a 2016, but please remember NALSA has recent data also. I'm just skipping this. Okay. Okay. Now I'm going to discuss some of the vital aspects of lokalat and permanent lokalat. There will be 3 issues we have. If lokalat award is a final, can we challenge the lokalat award? Because what happened? Sometimes power imbalance, power might be plays a role, right? Or sometimes what happened in the name of compromising, in the name of compromising, one party may kept in disadvantage way. So in that cases, what could be the remedy? Right, we should understand, right? Then what about the permanent localit? Okay, I haven't discussed that. I will discuss it later, permanent localit, but that's a second issue. Then how the permanent localit can decide fine, because this general localit and permanent localit, there is a difference. Okay, I will discuss. So let me get into the case. Punjab National Bank versus Lakshmikant Rai. This is a case. Now please remember, um, yes, you are right, Sen. Public utility services, you are permanent localit. I will come. Okay, in this Punjab National Bank, what the court held with regard to appeal, any civil appeal you can file under CPC section 96, appeal or second appeal. But as far as localit is concerned, though the matter is referred under CPC section 89, still you cannot file appeal under CPC. If you want a challenge, then you have to go to Legal Services Authority Act. But what Legal Services Authority Act says, there is no appeal. It's a final and binding. So that's a general thing. But there are exceptions. And please remember, Parmat versus Jagbar Singh and others, what the court held, okay, if you have any objections, you cannot invoke inherent powers of the court. 151, it talks about inherent powers of the court. You cannot invoke that provision for filing the appeal. Then what is the remedy? You can invoke constitutional remedy. Article 226, you can invoke. Venkatesh versus Oriental Insurance Company. So what the court held, so it's a duty as per section 89. So of the CPC, it's a duty of the court to look at it, whether there is a case which is fit for local health, so that it can be resolved amicably and with satisfactorily and quickly. So that way the court has given its observation. Okay, Manshiklar Vitaklar Saukal, state of Gujarat. If the local exceed, okay, its power or abuse of power, or you can say that there is a lack of natural justice, then it cannot be interfered by the court under Article 226 and 32. Right? So it can be very well challenged. So please remember, this is the observation of the Gujarat High Court. Now, in fact, there are many cases related to lokalat, but I have taken very selected cases so that the issues will be common to remaining cases. Even you can look at lokalat, if you put the term, you may have too many cases. But I have put very 5-6 cases so that the issues may be similar in other cases. Now, Manju Gupta case is very interesting case. So what happened in that case? Just look at it. Look at the facts. Then I will come to that argument. It's a motor vehicle claims. Now, please remember, as far as that referral of disputes is concerned, motor vehicle claims you can do that, and recovery of debts you can do that. So here in this case, motor vehicle compensation claim has been referred. While referring, now what happened? There were several irregularities done. Even the presiding officer of the same case also become the presiding officer of the local earth. That's one thing. Second thing, let us assume the claim was, in this case, a girl child. Now you imagine the age, 3 years old, right? Now if you apply the multiplier, it could have been wider. That's one thing. Second, last are both legs. Okay, he asked for compensation somehow high. Okay, he asked for compensation claim before the court, right? The motor vehicle tribunal, since the case was prolonged, since local opportunity was given, so he agreed to refer his claim to local. So what he did, he settled the claim for 30,000. Just ask yourself, a person who lost, rather a child who lost 30,000, sorry, 2 legs, and got compensation for 30,000. Do you think it is right option, or do you think it is the right amount? Just imagine. No, no, right? So this was the issue actually. So it was happened in UP. So as a result, what happened? The right newspapers, local newspapers have issued that. Then High Court of Allahabad has taken sumoto. Sumoto it has taken. Then it has increased the compensation. Now what it did, instead of hearing the case from the beginning, it asked the insurer, at least could you able to hike or not. Then they agreed. They, in that way, it has been increased up to 1,10,000. So what the observation of the High Court? In the name of speedy resolution, interest of the party is supposed to be sacrificed, and interest of the insane and minors disabled supposed to be very well protected. So please remember, many of the localites, this thing happening in the name of speedy disposal, many of the times one party at a disadvantage. So that's where, as a person who is giving legal aid services, we should be very cautious. We should be very cautious, because many of the legal aid cases always refer to local earth or mediation. So that's where our role comes important. We should ensure that the parties' interests have been protected. For example, you may not get, let us say, 5 lakh compensation, but at least 1 lakh, 2 lakh, if you ensure, that's fine, right? But here, since High Court kind of did summary trial, 1,10,000 additional. So if you look at that, the compensation was 140 overall. So anyway, if it might have been done earlier, there might have been fruitful negotiation, right? Yeah, still it very less. That's why I'm saying. So if at the time of a local hearing itself, if the parties have done diligent work, because that's where the power imbalance, that's where the Gujarat High Court also comes. So if any natural justice have been violated, or something ultra-vires have been done, that is local earth exceed its power, then okay. So that's where we must be careful. So local earth is not a okay. In local earth, it's not a kind of decision making body. It is a facilitating body, right? So though the award is final, it doesn't mean that it can be you can agree anything, right? So that's very very vital. Okay, bar council versus Union of India. So there was a challenge about establishment of permanent local earth, and Supreme Court upheld the validity of this permanent local earth. Now please remember, the title I put it can, but actually it is cannot. Why I put it can? If you look at the issue, you understand. Before getting to issue, I will just give the little bit intro about permanent local earth. Let's look at this. So transport service, postal, telegraph, power, electricity, public consumption, sanitation, hospital and dispensary, insurance. So these cases, these services are considered as public utility services. So you can approach these cases or any cases connected with that to the permanent local earth. So how the permanent local earth functions, I will tell you. With regard to permanent local earth, now presiding officer is a judge, right? Second, again other members you have, but permanent local earth have a permanent seat, or even if it is having a temporary seat, but it is having a kind of decision making power. Unlike local earth, permanent local earth have the decision making power. Now how it works, it will hear the case of public utility services related, it will hear the parties, then after hearing the parties, it try to make the parties to resolve themselves. If it doesn't workable, then permanent local earth itself can decide the case. That is, it can decide the case on merits. Please remember, in the general local earth, the local earth constituted under section 19, it cannot decide a case on merit, but here permanent local earth can decide the case on merits. As a result, it can pass decision made award, right? In local earth you have settlement award, here it is a decision made award. Again, similar provisions, this award become final and binding, you cannot challenge the award, right? So there are some cases also. Now the first case I'm telling you, there is a case. Now what happened? State government, Karnataka state government has issued the notification circular, and it says that all the public utility services falling under the category of permanent local earth. As a result, you can refer dispute related to these services to local earth. Now, one such case was one Tamayalapa, right? State, it's connected with recovery of debt by the SBI, right? So what the court held? No, you cannot approach this, right? So anyway, finally the court view was permanent local earth cannot hear the banking related case. As a result, many of the cases which have been referred to local earth again gone back to the debt recovery tribunal and other forums. Just look at this. So 100 cases have been withdrawn, and so 800 cases were filing. Then they might have again referred back to same. Just Charan Kaur and others versus state officer of Chandigarh. So please remember, it's an interesting observation, because in the local earth, it's a settlement award, but here it's a meritorious award. So that's where the court held that you cannot file an appeal, but you can file the review petition. You can invoke any kind of powers under 226 and 227 of the High Court for permanent local earth. This bar council case already I discussed. Dalvinder Singh and versus permanent local earth. Now, please remember, permanent local earth cannot pass. Let us say some restraint order, or let us say interlocutory orders. Permanent local earth cannot have that option. So this is very, very interesting. Though it's like a forum, like interlocutory or even arbitrators, they can have a interim awards, or you can say that interim measures they can pass. But here, permanent local earth, it cannot have some kind of interim measure. Let us say interim award, let us say interim compensation, they can decide. But that is differ from, let us say, you cannot pass this path until we decide. That kind of order you cannot pass. That only done by the court or other forums, not permanent locality. Okay. Okay, United India Assurance versus Ajay Sinha and others. Here in this case, what happened? There is an element of fraud involved. Those who want, you can read that case. Due to time constraint, I'm not highlighting the exact dispute here, but very interesting. So in that case, what happened? Insurance claim was made, but the insurer had the doubt about the genuineness of the claim. Okay, genuineness of that claim. So he has raised. Now, okay. So here, in this case, a kind of element of fraud is being raised. Though insurance claim is falling under public utility services, but the dispute is connected with how it is been made, the claim and versus as well as the instruments. As a result, the insurers say that no, we cannot agree the local earth, or we don't want to get into local earth. So as a result, what happened? The court held that in case of grave issues involved in any claim, let us say though it's look like motor vehicle claim, but there is element of fraud involved, then that in general, you can, for fraudulent claim, you cannot go for compromise. So that's where the non-compoundable temper is used. So any kind of non-compoundable claims or non-compoundable offenses, you cannot refer to local permanent local earth. So this is the decision in this case. Okay, I am stopping here. I am waiting for the questions. Even I am waiting for your comments, genuine. Okay, your concrete comments and suggestions, so that I can further improve my sessions.
Okay, thank you very much, Dr. Marisport. So, any questions are there? Please raise your hand, or you can put it in the chat box. So we will read out for you. You can raise your hand, or you can put question in the chat box. Can awards of like other Lok Adalat be challenged?
That's where actually here local awards cannot be challenged in the form of appeal, but you can challenge in the form of invoking high court's remedy, which is available under constitution. That is 226. You can invoke inherent power of the high court. Then you can challenge it in the form of writ, but
So,
you cannot
what
challenge
should
the
be the
award
ground for that then?
on the form of
Yeah.
merit. Please remember, meritorious challenge you cannot do, but in case of any apparent irregularity, very limited case, like Manju Gupta case is an example. So apparently, if you find it, then you can do that. Yes.
Then
Any other
482
questions?
CRPC, there's a remarks 482 CRPC.
What? 48? Yeah, 482 CRPC, that is inherent powers of the High Court. with regard to quashing or with regard to giving some remedies, but that's not available. That is not connected with this local alat. That's not
Okay.
not at all coming to here. Coming this particular topic.
Okay. Another thing, like what is power? That is one of the type of arbitration and mediation.
What is
I
power?
don't know the question again. You have to reframe, Rishabh. What is power? That is one of the type of arbitration and mediation. I don't understand the question.
No, I assume that whether power is a kind of arbitration and mediation. If possible, he can unmute and ask the question. I can able to answer.
Just participant, you can raise your hand. We have a couple of 2-3 more minutes, so we'll take up some questions. Or yeah, definitely will be already. We have shared the material in the Google Drive. Please go through it, and we'll share again. Yes. Any other questions, participants?
Okay,
So what
actually,
is the
what
lok adalat? Like what's your how
what is
student
it?
can role of law student, how they can be a part of lok adalat and contribute in this initiative.
Okay, actually, there are legal aid clinics functioning in various places. In fact, Kalpesh Gupta able to share you because he used to volunteer some of the legal aid activities. Even if your institution is tie up with, let us say, taluk level or district level local health, you can facilitate. But that time, what happened? If you are assisting any clients through legal aid clinics, so you can ensure that your client's interest should not be jeopardized. So that way you can work it out. Okay, Kalpesh, actually, one thing I would like to highlight here in the dispute resolution types, I haven't highlighted what is avoidance. Okay, avoidance. Here, avoidance means, let us say, once a particular dispute is happen, or you are having a contract, how to avoid a particular dispute, or how to make sure that even the same dispute should not happen again. So that is known as avoidance. Now take the case of customer care services of many banks, or you can say that many telecom services, that is be it Tata Play or Airtel, those DTH, those things and all. It's facilitating to avoid the disputes. If these customer services are not there, let us say TV is not working, instead of you approaching them, you directly file the complaint. Right, let us say your debit card, there is an issue, right? If you contact the customer care, you can lock it and other things. So at least immediately you can do that. So this way they try to avoid the disputes, so they may help. So this, there are some institutions and right now focusing on dispute avoidance policy.
So can we like for example ombudsman, can you put in this category? They're avoiding dispute or resolving dispute,
No,
banking
they are
ombudsman,
resolving
insurance
disputes.
ombudsman,
They are resolving disputes, but not avoiding.
resolving. So
Yeah,
yeah.
they are resolving.
So
They,
can
yeah,
you,
banking
yeah.
ombudsman or any ombudsman, you would say that it's like a one kind of forum, but they are resolving the disputes, not avoiding.
Can we call it as a part of ADR to some extent?
Uh, Here, banking ombudsman, I would like to say ADR. Insurance ombudsman, I can say, but let us say some of the ombudsman constituted under service category, central government. I am not going to say that it's a kind of ADR mechanism. It's a special forum constituted, not the ADR. But banking ombudsman, it's
Okay.
a kind of ADR.
Banking.
Okay, so
Yes,
that way we can
participant.
do.
Here the last question. Yeah, definitely, definitely. Like for example, this is personal experience. Some of faculty members are also here. They keep inviting. Okay, we need support from the students, right? Especially in the national law adalat. So
Yes,
obviously,
yes,
very great
yes,
opportunity for student to be a part of those things. You will learn the proceeding, how it
yes,
happens
yes, yes.
from morning
Yeah.
to evening. I've been a part of, so it's very great experience. Rather than definitely we attend the course like usually, but again, great experience how people are coming from different part of uh, you
Uh,
know the region for
in
different
fact,
kind of cases.
due to time constraint, only one example experience I haven't shared. Permanent local health. Please remember, literate people can be cheated. or can be deceived by the lawyers. In fact, in a nutshell, I am telling you, one of my own cousins have been told that Lok Adat forum as court. Lok Adat forum as court. See the situation. They are software engineers.
Sure.
So they
Yeah.
themselves suffered.
Yeah. Okay, I think we have taken almost all the questions. So thank you very much, sir, for spending valuable time, and you have set up a base. What is ADR? Obviously, participant. This is our idea is to give you a basic understanding or ignite, your minds to read out further. Obviously, we cannot go into details. So the idea was to give a highlight in previous sessions also. So like I hope you got to know what is ADR, different kind of mechanism with some example and cases. And tomorrow, one of our research person will be discussing on the branches of ADR, arbitration and mediation tomorrow, and then obviously another session is lined up. So thank you very much, sir, on behalf of organizing committee. Look forward to see you and continue support. You are there since beginning and associated with this
Sure,
course. So
sure,
look
sure.
forward to seeing you. Thank you very much.
Okay, okay. Thank you, Kalpesh, and I am always available for you. Even if the students are having any issues, I can share it. In fact, one book I asked the student to read, Successful Negotiation Strategies and Skills by George Sheedel. In fact, Kalpesh, if you wish to share it, also it is available in Library Genesis.
Okay, okay. Please share me
And
detail. I will share with the participants.
no, Library Genesis, you can find it that book.
Okay, sure, sure, sure. I will share.
And in fact, I am telling you, there is a course also offered in Coursera, Successful Negotiation Strategies by same George Sheedel only. Those who want to learn negotiation and types of dispute resolution and all, they can really look at that particular book, and even they can attend the course. Okay,
Sure,
very,
sure,
very interesting course. Okay, it would be really interesting. Okay,
sure, sure.
thank you.
Thank you very much.
Okay, okay, thank you. May I leave, Kalpesh?
Yeah, yes, I can. Thank you very much,
Okay, thank you.
and all the participants. Thank you very much, Pooja, Dr. Kaustubh Bakshi, and Harsh for joining. So look forward to see you tomorrow. Good night, all.